appreciate that comment, I don't appreciate that conduct, but it's not totally necessary. There are many reasons why women and men. Have anybody read Deborah Tannen's book? You just don't understand. Communication styles between men and women are quite different. Women, though it's changing, are conditioned to want to be liked. They're conditioned to avoid conflict, to want to fit in. Anybody who knows me knows those kind of things don't apply. But I mean, that's me. There are other people who have a problem saying no. And what is often happening, this woman is not saying anything to you. She is communicating it, but she's communicating it in that female style. The point is, there are a number of reasons people don't complain. They don't want to get the harasser in trouble. Being conditioned to be passive, they've been told, just ignore it and it'll go. I mean, when you're a little girl, this guy's teaching, just ignore it and it'll go away. And that's what many women hope for. If I just ignore it, it'll go away. There are those women who are in the old traditionally male jobs, and they think, well, if I say anything, they're gonna think I can't take it, and I can't be one of the guys, so to speak. There are all these reasons why people don't come out and say it, that they don't like. But it doesn't make it welcome because you aren't told. And then there's certain things that are inherently wrong. Nobody has to tell you where you don't put your hands. We had a case here a while back where the person had physically touched a co-worker. The person was terminated. At any rate, we had a hearing, and the person went through great contortions to explain how they didn't have notice that they weren't supposed to have committed this act. So the person was sitting there, and I said, your son's sitting with you, so I take it you are a married man, correct? He said, yes. I said, and you know that the complainant is also a married woman, don't you? He said, yes. And you know you don't put your hand on the private parts of a married woman who's not your wife, right? And so he says, yes. So, I mean, there's certain things there's certain kind of, nobody needs to tell you, you don't need a rule for that. Another thing I want to talk about is confidentiality. Certainly we try, thank you, we try to maintain confidentiality. When a person comes in with a complaint, we try to maintain confidentiality to the extent we can. However, at some point, if there's going to be a disciplinary action taken, remember, both parties have rights. The person is the fundamental due process is the person needs to be able to confront this accuser and know the charges against them. I recently had a situation where someone was complaining that they didn't want the information passed on to the harasser. So I said to the person, all right, suppose someone, let's personalize this. If someone accused you of something, if I told you I'm going to discipline you, but I'm not going to tell you what it is you did, and I'm not going to tell you who made the charges. Is that fair? So you've got to understand, we're trying to balance rights of two people here. One other point I wanted to get to is third-party harassment. And oftentimes, this is something that's not recognized. We talk about someone getting a better grade. Suppose a professor and a student have a relationship, and say another student feels that they're affected, i.e., the professor's significant other, if you will, friend, whatever, gets a grant. They get support, they get more attention. I think the seminal case on this was out of Washington, D.C., where I'm also from, and government employees. Person was a GS2, working for the director, the agency director. Now, if any of you work for government, you know that those grades come every 2 or 3 years at best. Person started a GS2. In 10 years, she was a GS12, which means that she was getting a grade every year. All the women who were working around her weren't getting grades. They filed, and they were able to prevail. So you need to be mindful that that's a form of sexual harassment too. I'm going to close mentioning, I think, we have, Jonathan mentioned the Supreme Court cases. We have, as I said, I mentioned one Iowa case, the one with the Doughboys. In that case, with this woman who was working on the assembly line in a male-dominated area, not dominated position, she was subject to every type of quid pro quo, it was more hostile environment. There were employees who pretended to be engaged in the sex act in front of her. They called her bitch, they called her the other words, grabbed her, and sometimes she complained, sometimes she didn't. The significant point in this case is the supervisors were also involved. In keeping with Ellerth and the other cases, one, they didn't have a policy. They didn't, when she complained, nobody paid attention. They didn't have a good sexual harassment policy, and certainly wasn't widely disseminated. We have another case, and it's Bosley versus Excel. And this one, I think it came out this month. And this one, we had a case where, and it's another factory case, but the principal I want to get across, this couple had been married. The marriage went south. They got divorced. But the male part of this team he was harassing the female to the extent that she and her coworkers were complaining about it. And management said, "This is your problem. Keep it out of the workplace." Finally, one day she just snapped and she pushed up past her supervisor to get to her former husband. She had it. At any rate, she was fired. One of the things I want you to be mindful of is just because a person has had a relationship at one time, what I found in my experience, is that administrators said, I really don't want to get into that because they had a relationship once, but it's gone. And as the court said, that it is no longer private when it becomes public, when it comes into the workplace and unwelcome conduct is involved. Okay. Am I done?
5 minutes.
Okay, 5 minutes. Last case I want to tell you about, also an Iowa case. In this case, it was in a high school setting, and child was alleged he'd been molested by a teacher for several years. And in that case, he sued the school system for negligent hiring. What's significant here is while the court didn't find in that case that the school was liable for negligent hiring, Iowa courts have now recognized negligent hiring as a cause of action. What they're doing is moving beyond the Supreme Court standard, which says that you're responsible for your supervisor's conduct and sexual harassment. You are also responsible if you knew or you had a good reason to know that this person should not have been working with children. Okay. All right, I think I'm coming under. Says my voice is low.
Okay, and what questions do you have for our two speakers? All right, go ahead.
Something here. You were talking about university policies.
Yes.
Well, I'll just give my little story here. A couple of years ago, I'm a student here, what you call one of the non-traditionals.
Mm-hmm.
A couple of years ago, I was working at the library with a bunch of other students.
Mm-hmm.
And one day I'm calling to the office of
Right.
my meeting supervisor,
Right.
and supervisor,
Mhm.
and give me a letter
Mm-hmm.
that says, you're accused of making sexual comments that could be seen as having sexual overtone of the type of
Mm-hmm.
Susie looks pretty today, or Susie's wearing a nice dress, or
Right.
whatever. If you ever make comments of this type again, you'll be fired.
Mm-hmm.
And I said, no, wait a minute. I'm not gonna sign this, but you have to. I said, no way.
Mm-hmm.
You've gotta tell me what I said.
Mhm.
I said, first of all, you're assuming that the accusations are true, without giving me a chance to defend myself.
Right. Okay.
You're not allowing me to face my accuser.
Right.
I said, it's just a matter of common sense.
Mm-hmm.
When whoever came to you with the complaint
Mm-hmm.
or complaints,
Mm-hmm.
did you say to them, did you say something to Randy about it,
Mhm.
made him uncomfortable. Nobody had
Mhm.
ever done that.
Mhm.
And they basically told me
Mhm.
that I had to sign a fire. I said, no, I'm not gonna do that. You know, I ended up going to the student's office and everything. Looking back upon it, what I should have done was come to your office.
Mhm.
But I never did find out what complaints supposedly were.
Mhm.
And it, you know, and just on a practical matter, there's an obvious problem.
Mhm.
How can a person avoid repeating a behavior if, you know, you don't even know what it is?
Precisely, so I think that's what I alluded to
Yeah,
earlier.
now, and
Yes.
I had the supervisor in the library who was in charge of that section.
Mhm.
I asked him about it. I said, look, it seems to me that as a somewhat older white male, that I'm basically guilty if accused.
Mhm.
Under a certain, and he said, well, yeah, basically that's true. And that's like I said, at the
Mhm.
end, what ended up happening,
Mhm.
the policy, I felt it became so hostile towards me there because basically I felt I couldn't even engage in routine conversations with my fellow employees because if I said anything,
Mhm.
it could be reported as a harassing comment
Mhm.
and it would be my word against theirs.
Yes.
Well, or actually it wouldn't be my word against theirs because I wouldn't be told what I had supposedly said.
Right.
So I ended up quitting at the end of the summer.
Mhm.
Now, I've since talked to other people
Mhm.
who have had similar things happen to them at this university.
Mhm.
And it seems to me that it's not all that uncommon for this kind of thing to occur here. I should make it clear, I am in favor, you know, I believe in the ideals of the sexual harassment
Right.
policies,
Mhm.
but I believe frequently,
Mhm.
like you were talking about here, in the informal complaint process,
Mhm.
well, in the formal complaint, both parties have rights, but you say in the informal complaint process, the victim doesn't have to meet with the accused in the formal complaint process.
In the informal, right.
Right, but, so that leads to the abuse of situations like mine where the accused doesn't even know who's accusing
Okay,
them.
well, let me see if we can address this. First and foremost, how long ago was this?
This has been 2 years ago.
It's too, I'm sorry it happened. It should not have happened. Unfortunately, you didn't go to Evie. If you'd come, now remember, I'm responding to the story as you're giving it to us, okay? All right. If I'd known, it wouldn't have happened. I don't think, this is not the problem here is not the policy. The problem here is it was not applied correctly.
Yeah.
Certainly.
I do understand that.
Yeah, certainly, if we were talking an informal procedure, remember, as I said, that DEO supervisor, who's ever handling it, may be delegated to someone further down the chain, whoever is handling it has a responsibility not only to talk with the victim, but to talk with you.
Yeah.
So if it had been informal, they should have talked with you, says, well, we have these reports, what do you have to say? So here again, this is not anything wrong with the policy is great. I think so. The policy is very good, but I think here it was misapplied. One of the reasons we have training sessions for the public, for supervisors, we're working at it. The DEO council just had a training for DEOs. It's so that people will understand. My experience here at Iowa State, as the nearly 5 years, people want to do the right thing. And what we may have had in your case, unfortunately, is a misapplication. If you have or find yourself in a situation again, by all means go to Evie. Evie knows my telephone number, and if she's got a problem, she doesn't mind calling me.
Something.
Go ahead, sorry, I was gonna say.
Something I would be curious in knowing.
Mm-hmm,
Now, I became convinced
mm-hmm,
that a lot of what happened, there was in the department I worked in,
Mhm.
there was a lot of, among the other employees,
mm-hmm.
a lot of sexually oriented bantering.
Banter,
you know.
okay, that happens.
And I occasionally joined in,
Mhm.
I'm a pretty outspoken person, so I
Mhm.
very well could have said something, but
Mm-hmm,
I was convinced that I had not said anything that was any worse
Mhm.
than my fellow employees.
Mhm.
The difference was, they were 18, 19, 20 years old,
Mhm.
and I became convinced, and I'm still convinced,
Mhm.
that I was judged at a different standard because of my age, because
Mhm.
of being older than the other employees,
Mhm.
the dirty old man.
yeah.
And I was curious, how do policies address something like that that could be more age-based?
Well, here again, if this had, if we were going to roll the film back and do this right, so to speak, if it had been looked at by the Affirmative Action Office, we've had situations where we've had to go in and talk to everyone that was involved, not just the person accused. And you're quite right. And when you're dealing in subcultures, there's a code. There's certain things this person can say. Okay, it's like the old, the dozens, where you can say anything in the world about somebody. Don't talk about their mama. This is the kind of so you may have been a victim, victim, so to speak, of that. There may be some some code. It's okay between the 19-year-olds to say these things, but here again, what I would say is, if you're in that position again, by all means, come to the Affirmative Action Office. If you know of anybody, you said that it's common, maybe you refer them. We can't deal with things unless we know about them.
Okay, and there was a question.
Jonathan wanted to speak. I want to
Jonathan.
address that.
Yeah, just a couple of quick general points on that type of situation also. I think this is a good example of where knowledge is power in this area. As a lawyer who frequently deals with non-lawyers, I tell people it's worth your time, if you're interested or involved in these issues, to read some of these documents, like that guidance I mentioned from the Office for Civil Rights, or the university policy, to familiarize yourself with it. If you know what your rights and responsibilities are, you're frequently going to be in a much stronger position when you're dealing with people. Universities, and I completely understand this, you'll hear frequently feel that they have to react very quickly and decisively to sexual harassment complaints because there's such a fear of litigation out there, and many of these cases have made big headlines. Well, there have been a number of situations where universities have done that and then gotten their hands slapped for going too far, too fast. There was a small institution in the state of Pennsylvania where the president said we have to take a strong line on sexual harassment. They had 4 employees over the course of a couple of years who were fired for sexual harassment, and 3 of them were reinstated by arbitrators. You would think after the first or second one that the president might have gotten the point, but he didn't. And the university, I would think the university attorneys probably got involved at some point and said, look, we have to stop doing this. In fact, if you look at the policy guidance from the Department of Education's Office for Civil Rights, the office that protects students at the national level, that guidance says that due process is a very important component of complaint procedures, that's the best way to get at the truth. Now, it would be very helpful to have that kind of knowledge and be able to even specifically cite to something like that when you're in a circumstance like this, which is part of the reason why I think it's, again, that knowledge is power, that people really should familiarize themselves with the policies and with the standards in these areas. The Title IX, by the way, the regulations only require that complaint procedures be prompt and equitable. They don't give all the details of what that means, but the idea of equitable includes the concept of due process for the accused.
Yes, they gave me a perfect entree. I stopped at the Training and Development Office today to pick up these little brochures, Sexual Harassment, Stop It Now, It's Illegal. It is a summary statement of the policy. They're over there for you to pick up. There are a few questions and answers. And also it lists the offices where you can get more information about sexual harassment. One of the things I'd like to point out here, though, on this, these are, as Cindy told me today, they're old. It has the Employee Assistance Program number here, which, and they're now the university uses the Richmond Center. That number is 232-5811. You can, if you didn't get it, you can find it directly. But other than that, the information's accurate, and I'd suggest just pick it up.
Okay, thank you. And there was a question in the back row.
Of all the conflicts that the university resolves,
Mhm.
what percent of them fall in the category of sexual harassment?
Of all the conflicts that the university resolves, I cannot give you a definitive answer on that. There's some things that are resolved, for example, that my office might not ever see. The matter with the one I talked with you about tonight about the sexist joke. I knew about that from researching some, the affirmative action office, I never saw the case. Do you follow what I'm saying? So there's some things I would not say. I could not tell you, I can't give you a definitive answer on that.
A couple quick comments, though, from a national perspective on the trends. When I was at OCR, in the course of just 2 or 3 years after the Anita Hill and Clarence Thomas hearings, when sexual harassment really got a lot of national headlines as an issue, the number of complaints nationally that we saw at OCR doubled in the span of 2 to 3 years, and it continued to grow at a very high rate. I'm sure it's still rising at this point in time. Also, there have been a couple of national studies done. Now, these are not necessarily perfectly scientifically valid, because when you ask people, have you been sexually harassed, they will have differing definitions. But at least with students reflecting on their experiences in kindergarten through 12th grade, for example, over half of the female students who were interviewed in these national surveys said that at some point in their school careers they had been subject to what they considered to be sexual harassment in school. And university studies that I've heard about would suggest the same thing. So the fact of the matter is, most of the cases don't get reported at all. And one thing that the greater public consciousness may do is to, we may see an increase in complaints, not because there's more harassment occurring, but because people are finally having the courage to report it.
Other questions? Yes, President Jiski.
Could you comment from the perspective of the federal law and the court cases as to the circumstances under which a faculty member would be seen as a supervisor in the terms of the recent case? And just to shape your thinking, the faculty member's role as a teacher of a class, on the one hand, and a faculty member's role as a supervisor of a research assistant on the other. I use the word supervisor, as the director of a research assistant. Are either of those supervisors in the sense of the law?
Right.
That is where the university is vicariously liable?
Well, the case that I mentioned in terms of vicarious liability and where I specifically talked about supervisors, that's actually a decision under Title VII of the Civil Rights Act. So technically speaking, that only applies to an employer-employee relationship. So it would not apply to the faculty member dealing with the student. The standard that applies to the faculty member dealing with the student who is not an employee falls under Title IX, a separate statute. And that's where I mentioned the other case that said that the institution has to have actual notice of the harassment and to have been deliberately indifferent to it. This was a controversial decision. A lot of people don't agree that there should be that lesser level of protection for students than for employees. You asked, though, another part of your question, which is significant, is what is a supervisor in the higher education context? Because there are all these relationships with teaching assistants, graduate students. Even if you think about senior colleagues who vote on somebody's tenure, what about your senior colleague who's not the department chair, but who is voting on your tenure as a junior colleague? None of those questions are really answered specifically by these Supreme Court decisions. So they would look at general principles of agency law. Traditionally speaking, my own feeling is many of the courts have interpreted what a supervisor is somewhat narrowly. Someone who's in the chain of command above you, a department head pretty clearly would be. But I think a faculty member who has authority over teaching assistants, there's really nobody else that would be their immediate supervisor in many cases. So I think in those situations, the faculty member would be considered an agent of the institution.
Yeah, I agree. The other thing that is coming to the fore, many TAs and assistants, they are beginning to unionize. And what we have with the research assistants, you have a hybrid. This person is student as well as employee. And I think how they are classified in a particular situation is going to be fact-driven. What is the relationship between this student and this particular faculty member?
Yeah, we used to fight over those cases when I was at the Office for Civil Rights. If a complaint was filed by a teaching assistant, the EEOC would try to buck it over to the Office for Civil Rights and say, well, look, this is a student case. whenever they'd come to OCR first, OCR would try to buck it to EEOC and say, no, this person is an employee. They talked for years about coming up with definitive guidance about when someone was or was not an employee, and that guidance has yet to be issued. So it's really going to be a case-by-case basis.
Yeah, we often look to California, and I think that California is recently, what school was that? Students won the right to.
CSU system.
Right, they've unionized, they're negotiating. Now, they're going to be employees, they're going to be considered employees.
Yeah.
So we'll have to look for the first sexual harassment case, to answer your question, not just get it comes out of that. How is this person
There's a
classified?
very important case in the law on the role of faculty and governance
Mhm.
out of Yeshiva University.
That's
It's
right.
20
Right,
years ago.
yes, exactly, I remember
In
that.
which the faculty were found to be in management.
Mhm.
That's right.
Yes, I
As
remember.
a general principle.
Right, and that's why they couldn't unionize.
It seems to me
Yes.
to lend some weight to the argument that they
Mhm.
may in fact be supervisors in
Mhm.
a broader sense.
Yeah,
Yes.
yeah, to follow up on that, they wanted to unionize, and they were found to be
Right.
in the management, so they couldn't do it.
And
Yes.
another factor that would make you look more like a managerial employee is if you empower faculty members to be able to address acts of harassment, for example. You're essentially deputizing them as agents of the institution. I worked on a case involving MIT and their sexual harassment procedures when I was at OCR. And they talked about this great system of open access where every faculty member was considered a complaint handler. So a student could go to any faculty member at the institution to file a complaint of sexual harassment. The problem, of course, was that most of these faculty members had no clue that they were designated as complaint handlers and didn't know the first thing about sexual harassment. And they told us, well, you don't expect us to have mandatory training for our faculty, do you? We could never get that. In fact, what these Supreme Court decisions suggest is you do that at your own peril. Because if you're going to deputize these people to be able to have that authority to address sexual harassment complaints, then you are essentially creating them, or at least removing any doubt about whether or not they are managerial employees who could bind the institution by their actions.
Yes, Brian?
If memory serves, some of the charges against Simonson were based on the faculty handbook. And Judge Volkin asked for a review of those parts of the faculty handbook to find out whether they were administrative rules or not. And eventually decided that they were not administrative rules because they hadn't been so certified by the state. I'd like to know the status of that now, in the sense of how far along are we on deciding whether parts of the faculty handbook should be made administrative rules or not.
Well, Brian, obviously you weren't here when I said I wasn't going to discuss the particulars of any case. That is related to the Simonson case. I'm not going to discuss that at this point.
Could you make any comment on the handbook part of his question? Is that possible?
At this juncture, I think not.
I might be able to help in
Okay.
that there's been revisions of the Iowa Administrative Procedures Act,
Precisely.
which change the framework within which one must decide what is under the administrative rule-making procedure and what
That's true.
isn't. And we're in the midst of looking at our various handbooks, procedures, and policies to try to resolve that in a general sense. The legal framework for that has changed.
Right.
And we're dealing with it in that general sense. It's actually a pretty complicated
Yes, it
set
is.
of issues.
Yeah.
This
And
is obviously a thing that the faculty would like to know about,
You know,
because it affects the question of how the faculty handbook functions if we get into a push comes to shove situation.
No, and you're absolutely right. And the problem we are under is we're under a mandate from the Attorney General to move this very quickly, to at least set up the general machinery. And there are certain parts of our policies and procedures that have been essentially declared per se to be under this, and we're moving it through.
Mhm.
We're under deadlines that don't allow for hardly any discussion, frankly.
yes.
I think most of them
Mhm.
won't be of interest to people generally. They're of
Mhm.
interest to the lawyers. The more substantive policy questions, for example, are personnel policies. That's something that's going to take some time.
Yes. And remember that it's an ad hoc decision, so we've got to look at that.
What this new Administrative Procedures Act in effect says is that any rule that affects the public must go through a rulemaking process.
procedure, yeah.
And the question where we get into complicated discussions is, who's the public in this sense? Are we
Yes,
the public?
public, yeah.
Well, clearly, I'm a member of the public, and you are too, but for the purposes of the rules of the university, I'm not the public.
Yes, and,
President.
right, certain things are just, are gonna be particular, no one else is gonna care about this, excuse me, go on,
I mean, it's a fair question.
Yeah.
It's an important point.
yeah.
How about, Brian, if you had another question, and then we'll go back to the back row.
Okay, good.
Did you have something else?
Let me go on, actually.
Okay, go
That's what I said, go ahead.
Obviously, sexual harassment matters are tough things.
Mm-hmm.
And I have come over the years to question whether ISU is doing the easy parts of it, because there are some parts that we really can deal with. And this question of things in the faculty handbook being administrative rules or not being administrative rules seem to me to be something that we could deal with. Obviously, we can't control the behavior of every individual.
Mhm.
And I've been very concerned because some years ago, when I think we did the last revision
Mhm.
of the sexual harassment policy,
Mhm.
it came down to the general faculty, and I think in fact the university community, with a
Mhm.
covering letter saying, well, you know, all the deans and all the vice presidents have been working on this for months now,
Mhm.
and we'd like your comments. And what happened was that if you read the procedural section, which was 1 or 2 pages in it, you found out that the procedural section
Mhm.
couldn't figure out who was passing what document to whom when,
Mhm.
and had several sort of howlers in it.
Mhm.
And the faculty senate then responded and sent up some suggestions about that,
Mhm.
certainly the signals that the howlers should be taken care of.
Mhm.
And when the final approved policy came out, it turned out the howlers weren't corrected. It turned out that it was announced that the faculty senate had approved the policy, and whoever approved the policy was never made public.
Mhm.
And it seems to me that if we're really interested in it, we could at least fix up our policies. We can't control people, but we can get our policies right.
Well, certainly, as Dr. Jiski said, you're talking about 2 tracks here, Brian. We've got to deal with the APA before we deal with that. It can be done, but,
What difference does it make whether?
I'm sorry, there's someone behind you who had a question next.
Go ahead.
Go ahead.
yeah.
I was going to ask,
Mhm.
how far up the chain of command
Mhm.
responsibility falls? We have a general of late that's in hot water
Mhm.
that has harassed the wives of his subordinates.
Right.
Now, in here, obviously, the wrong has been more than
Right.
wrong has been
Okay.
done.
Yeah.
Who is responsible up the chain of command? Is the Joint Chief of Staff responsible for this? Is the people subordinate, let's say, in Department of Army or other people are responsible for the conduct of the general, misconduct of the general? How do you sort this out, and who has any claim? Does a colonel have any claim in here? Does his wife can sue the government? What happens in between?
Well, here again, we're talking about notice. You want to comment on that? We're
Yeah.
talking about who's his superior, and did the superior have notice?
Yeah, and in terms of the actual laws, if we take it back to the university context for a moment, under either Title VII of the Civil Rights Act, the one that applies to employment, or Title IX that applies to students, it's the institution ultimately that has legal liability, not individuals. You don't sue an individual under Title VII or Title IX. There are some federal statutes, and perhaps, I don't know, Iowa law as well, whether there might be a state law as well, where you can sue someone for depriving you of your civil rights. So there are cases where you can have individual liability. But if you look at who binds the institution, and therefore who might be disciplined by the institution, at least in the supervisory cases, as soon as you go up just one level, if someone has some sort of authority over an individual below them, then it may be appropriate, obviously, to discipline that person. If people further up the chain know about it and fail to respond to it, then it may be appropriate to deal with them as well. So you have to look at, as he mentioned, who has the notice and who has failed in their responsibilities to respond once they've got that notice.
And we had a situation here a few years ago where, I think it was just before I got here, we had a, I'm sorry, you can't hear me? So we had a situation here just before I got here where a person had been engaging in very extensive sexual harassment. And apparently it was known by the supervisors and they just looked the other way. So that person was terminated and the others two were disciplined also because they knew. So when it went up the chain, when so the issue of notice.
Yes, did you have a question?
Well,
Oh,
I had kind
okay.
of a follow-up on what he had said.
Okay.
I was just curious, for those of us, those few of us here who aren't faculty,
Mhm.
what's the difference between an administrative rule and a non-administrative rule in the faculty handbook? I mean, what does that exactly mean?
Okay, well, as Dr. Jiski was saying, the Administrative Procedure Act is a set of laws. When we're talking, sometimes, here, until Judge Bolkin made his ruling, we considered our rule internal, not subject to the APA. He made this ruling. Now, we've got a couple of things going on. We've got the law being changed, as Dr. Jiski has said. So we've got to see how this ends, how this thing shakes out. I can't tell you what's at the end of the road. I can't even tell you where it's going until we get, until this thing is resolved. Does that answer your question? If not, then ask again.
I think so. So you're saying,
It has to do with the procedures by which the policy or the rule is finally adopted.
Adopted, yeah.
In the
Okay.
case of an administrative rule under the Administrative Procedures Act, you must have public hearings, and it must ultimately be adopted
Mhm.
through that process,
Yeah,
whereas a university policy in principle can be approved by the president.
precisely.
Okay.
It's internal.
that makes it.
Internal. Let me, if you've ever seen, I don't know, have you ever seen regulations from a federal government? And how, you know how they have the notice and comment period? Well, it's along that line where you have public input. Whereas heretofore, it was something that could be adopted. We had internal procedures that established how the rules were going to be. I know you had some concerns about how it was done, but it was all in the family, okay? No, nobody, the APA wasn't involved. Now, what Judge Bolkin is saying is that we would, under his standard, our faculty rules would have to meet the same standard as, say, if you were going to change the rules governing, see if I can come up with a state agency, say the PERB Board, Public Employee Relations Board, or the Iowa Department of Personnel, if they're going to change their rules. The difference is everybody gets to say something, okay, whereas before they didn't, all right? Question?
Question?
I was going to raise a different kind of question, and that is, the title of the session is Prevention of Sexual Harassment, and I presume implicit in the discussion is that by having well-established policies
Precisely.
and appropriate procedures
Yes.
and the possibility of discipline,
Yes.
that constitutes one approach to prevention.
Yeah. Well,
I
yeah.
want to make the case that that's inadequate, and I'm curious, particularly given that you operate nationally and watch a lot of universities, what can you tell us beyond this sort of dealing with problems? What have people done that, in your view, represents effective ways of preventing the behavior from occurring at all
Okay.
that is outside the law?
Right. Yeah, I think there are several things here that can be done. Training, not just under formal policies and procedures, but basic training on what sexual harassment is, I think is very useful for everybody in the university community, for students, for faculty members, for administrators, every single person on campus, basically. And the training that's most effective is not necessarily bringing someone from the outside who doesn't understand the university context. It's really important to focus on the specific context, students dealing with one another in dorms, faculty members dealing with students in the classroom, and what those discussions sometimes look like. A lot of times that kind of training, people resent it when it's forced upon them, like the faculty members at MIT that I mentioned. They said, well, it would never work. But if you have some sort of an orientation period, for example, for new students, or you have training for your RAs in the dorms, there are a lot of opportunities where sexual harassment ought to be one of the topics that is covered, so that it's not isolated and people don't feel like you're accusing them just because you're requiring the training. So I think that kind of approach is very good. There are some videos out there. For example, United Educators, which is a big insurance fund for colleges and universities, has produced a video on sexual harassment that many campuses use. And then getting those policies and procedures out there year after year, having them widely disseminated, having discussions on them, I think is very useful. If you have some faculty members who have some expertise and understanding of these issues, having some sort of roundtable discussions, I think, is very useful. People like to talk about this if it's in a comfortable enough environment and they don't feel under threat. When I give presentations to faculty audiences around the country, usually it takes a while for people to feel comfortable asking their questions, but by the end, you can't stop them. So trying to create an atmosphere that is comfortable in the sense that people don't feel personally threatened, where they really can ask open and honest questions and have some debate. So maybe you have deliberately speakers that disagree with one another to get that lively exchange is very, very helpful.
We have time for one more question. If somebody has one, please go ahead.
You brought up the thing about faculty around the country. How many different participatory universities have you been with that have this kind of a vague solution or trying to make it less vague?
You mean in terms of the kind of training and that sort of
No,
thing?
how many universities? You singled out one particular,
MIT.
one in Pennsylvania.
Right.
And I don't know whether you've had an interaction there, but have you been to a number of other universities that have kind of problems like this? Or?
Oh yeah, I mean, basically every campus that I've been to, especially larger campuses, this is an issue, and this is one of the most common issues that we get asked to deal with at AAUP. A lot of it, as I said, I don't think it's that sexual harassment is suddenly occurring where it wasn't occurring 10 or 20 years ago. It's that there's a much greater public awareness of it now. And that's why people are starting to grapple with it. The university policies that were in place 10 or 20 years ago are now being re-examined in light of some of the recent court decisions. And I'd say most university policies that I've seen actually are inadequate. And certainly the training and the prevention mechanisms are inadequate. One other thing I might just mention about prevention, if you empower people so that they feel that they can express the unwelcomeness, that's one of the keys here, especially for students that aren't used to doing that. They didn't feel that they had that kind of power or authority in high school, and all of a sudden they get to college and they're being told, you should speak up about this, whether it's to a fellow student or a faculty member. And so stressing the fact, for example, that retaliation is prohibited under the law. And the Affirmative Action Office can help send that message. You can have posters and things around campus that send that message. If people feel that they are empowered to stand up for their own rights, that makes a great deal of difference, I think, in preventing sexual harassment.
One thing I'd like to add, you said there's a greater awareness of sexual harassment. I think another thing that is happening is a greater awareness that something is sexual harassment. I can remember here again a story from my childhood. It was in junior high school and high school. There was a bully who harassed me. I mean, I look back when I was being harassed for years. And my parents had the boys will be boys. He, isn't this love and bloom and what have you. Finally, by the time I got up to 16, and this boy started to physically come toward me, then my mother woke up to that. I mean, I knew all along I wasn't comfortable. I couldn't articulate as a child, but I knew something was wrong here, and nobody was listening to me. And I think there's a greater awareness of the fact that something is harassment. Sending a woman flowers every day when she just indicated she's not interested, that's not legitimate courtship. We're talking, the person's being harassed. So I said it's twofold.
Okay. Okay, I would like to remind you that Tessie said there are some little cards that are over on the table about our local policy. And there's also a copy of Jonathan Alger's article, Love, Lust, and the Law, Sexual Harassment in the Academy. And so please pick one of those up if you have not. And if you have some time to munch on a cookie, Jonathan and Hesse will be willing to talk with you on a more informal basis. Thank you for coming.